partnership. In absolute community,
Kuya.
um, in absolute community, the spouses are considered co-owners of the community property, while in the community partnership of gays, there is no co-ownership. In absolute community, the rules which applies is the co-ownership, while in the community partnership, the rule which applies is the contract of partnership. Contract of partnership. As stated in the general provisions, the conjugal partnership of gains shall govern property relations if agreed upon the marriage settlements. And it applies for marriages celebrated after the effectivity of family code on August 3, 1980. Next slide, please. Next slide. So when does the community uh, community partnership of gains commence? It shall commence at the precise moment of the marriage, and it can only exist if there is marriage settlement. Either spouses cannot waive their right, interest, share, or effects of conjugal partnership during marriage. If made, it does not produce legal effects. This is because the rights of husband and wife do not vest until the liquidation of the conjugal partnership. So this is in accordance with the legal maxim, nemo dat qui non habet, or no one can give what he has not. Next slide. Properties brought to the marriage remains his or her property, and fruits and income considered conjugal partnership property. Note, however, that nothing prevents the future spouses from including their conjugal partnership properties acquired prior to the marriage. Next slide. Properties acquired by redemption, barter, or exchange, exclusive property of the redemption spouse. If acquired by either spouse through barter or exchange with property belonging to the spouse is exclusive property. If the property is purchased with the exclusive money of either spouse, then it is the exclusive property of the owner of the fund. Next slide, please. Administration of exclusive property. It belongs to the owner but may transfer voluntarily or upon order of a competent court. Here are the requisites that must be complied in case of transfer. It must be embodied in a public instrument and recorded in the registry of property. However, said administration does not include the power to encumber such property. So it is well stated that in case of transfer, the spouse cannot alienate, encumber the property, or dispose the property. Next slide. Onerous donations referred to in Article 114 of the Family Code are those where a burden of charges inferior in the value compared to the property donated is imposed. So in such a case, property remains exclusive property of the donee spouse, although the burden of charges were paid from conjugal funds. In such a case, the conjugal partnership shall be reimbursed for the advances made in favor of the donee spouse. Next slide. Under Article 115, benefit out of pure liberty of grantor, benefit is considered exclusive property. On the other hand, if benefit is accumulation or deductions from money during marriage or from salaries of either spouse, it forms part of the conjugal property. Under Article 116, all properties acquired during marriage is presumed to belong to the conjugal partnership. Presumption applies even if acquisition appears to have been made, contracted, or registered in the name of one or both spouse. Registration of a property alone in the name of one spouse does not destroy its conjugal nature. Next slide. According to Article 117, the following are conjugal partnership properties. Next slide. So, nasa folder niyo naman po lahat ito para lang mabilis tayo. Basahin niyo na lang. Next slide, please. There are tests to determine whether property acquired is conjugal or exclusive. The first is the manner of acquisition, and the second is in case of onerous title, source of fund test to determine the fund. If the property is sourced from the exclusive money, then the property acquired is exclusive. And if the source of the fund is from the conjugal property, then the property is conjugal property. Property obtained from labor, work, industry, or profession belongs to the conjugal property, but if earned prior to the marriage, it is an exclusive property of the spouse who earned it. On the other hand, debt contracted during the marriage, which he or she contributes towards the support of his her family, are not considered personal debts but obligation of the conjugal property. Next slide. Property acquired through occupation. The term occupation in Article 117 refers to the mode of acquiring ownership or dominion by the seizure of things corporeal which have an owner and with the intention of acquiring them according to the rules laid down by law. So here, those are the 5 requisites in order that things may be considered as acquired by occupation. Next slide. Same as fruits of the conjugal partnership due or received during the marriage, they are also part of the conjugal partnership. With respect to the property of either spouse, only the net fruits shall belong to the conjugal partnership. Net fruits, which refers to the remainder of the fruits after deducting the amount necessary to cover the expenses of administration of said exclusive property. Property acquired by chance, winnings from gambling or betting belongs to the conjugal partnership. However, losses therefrom shall be borne by the loser's spouse. Under Article 120, improvements on exclusive property, in order for this article to apply, the following conditions must be present. First, the property is exclusively owned by one of the spouses. Second, the same is subjected to improvements during the marriage. Third, improvements were made at the expense of the conjugal partnership or through acts of either of both spouses. To determine the ownership, the following rules must apply. When ownership is vested, the ownership shall be vested in favor of the conjugal partnership or the owner spouse only upon reimbursement. However, if reimbursement is made prior to the liquidation, ownership immediately vests. Next slide, please. If there is no showing that an obligation has redounded to the benefit of the family, the conjugal partnership is not liable. Exclusive properties as well are not liable for the obligation of the partnership, except in case the partnership assets are not sufficient, the spouses shall be liable. If during marriage debt is contracted with the consent of the other spouse or both of them, it is presumed that debt has redounded or accrued to the benefit of the family. Therefore, the conjugal partnership is liable for the indebtedness. If debt is contracted to marriage or contracted without consent, the consent of the other, the conjugal partnership is not liable, except if debt has redundant to the benefit of the family. So the next slides will be discussed by Ms. Angela.
be discussing sections 5 to 7 of the CPG. So, first section 5 is the administration and disposition of conjugal property. So, the same with the regime of ACP, administration and enjoyment of the conjugal property belong to both spouses, but in case of any disagreement, the husband should prevail. So, also the same with ACP, in the event of incapacity for the other spouse, the other spouse may assume sole administratorship, but uh, this does not include disposition and encumbrance. Okay, so the sole power of administration, as also discussed in the ACP, do not include disposition and encumbrance. So any sale that will be made by the spouse with sole administration will be void without the consent of the other spouse or without any written authority by the court. Next slide. Next slide. So the rule under the family code, this applies only to those alienation or disposition that is made in the effectivity of the family code, even if their marriage was under the civil code. Next slide. Next slide. So, if the buyer can invoke good faith in this sale for this requisite. So, first, if they perform verification of the validity of the title and inquiry to the authority of transacting spouse. So, next slide. So, donation of the conjugal property also is covered under the disposition. So, donation without the consent or without the written authority of the court will also be void. Next slide. So, disposition of spouses' interest in the conjugal partnership. This is only allowed in events of liquidation because their rights to their interest in their conjugal property only vests upon liquidation. So, next slide. So, the same with ACP, the dissolution of conjugal partnership regime is also upon the death of either spouse when there is a degree of legal separation, annulment or nullity of marriage, and in case of judicial separation of property. So, the same also with ACP. Separation in fact does not affect the regime. So, next slide. Sorry, so the last section para, liquidation, these are the brief steps now. So first, inventory of the listing of the conjugal property and the separate properties. Then next step is yung benefit na na-receive ng spouse, i-return nila yung equal value sa conjugal property nila, and then any expense na nakinuha na nakuha nila from their property, ibabalik din ng property. Then third, debts of the CPG will be paid by their conjugal property, and then any debts naman na personal will be paid by their separate property. Pero in case na insufficient yung yung conjugal partnership nila, they will be liable solidarity for sa separate properties nila. And then, yung remaining separate property nila will be returned to them. And then last, yung net remainder of the CPG will be returned to them in equal proportion kapag walang stipulation sa marriage settlement. That's all.
So I'll be discussing chapter 5. So separation of property of the spouses and administration of the common property by one spouse during the marriage. So it covers articles 134 to 142 of the Family Code. So for Article 135, so in the absence of an express declaration of in the marriage settlements, the separation of property between spouses during the marriage shall not take place except by judicial order. So such judicial order of separation of property may either be voluntary or of sufficient cause. Then what are the sufficient causes and grounds for reviving to the previous regime? So there are 6 sufficient causes and 7 grounds. So bawat cause, meron siyang kaakibat na grounds for reviving previous regime. So the first one is spouse of the petitioner has been sentenced to the penalty which carries with it civil interdiction, and yung grounds for reviving it is the termination of the civil interdiction. Second is the absence of the spouse of petitioner is judicially declared absent, and yung ground for reviving is the reappearance. Third is the loss of parental authority, yung sufficient cause. Then yung ground for revival is the restoration of the parental authority. So the parental authority, hindi sinasabi if which child, pwedeng common child between the spouse and yung within the marriage, or a spouse and another person. It also does not distinguish if it is a illegitimate or legitimate child. Then number 4, if the spouse of the petitioner has abandoned the latter or failed to comply with his or her obligations to the family. So yung grounds for reviving is when the spouse resumes common life with the other. So abandonment of yung obligations that are pertinent to this are the marital obligation, parental obligation, and property relation obligations. Fifth is the spouse granted the power of administration in the marriage settlements has abused that power, and the reviving ground is when the other spouse reauthorizes the resumption of the said administration. 6 is at the time of the petition, the spouses have been separated, in fact, for at least 1 year, and reconciliation is highly improbable. The grounds for reviving is the reconciliation and the resumption of the common life. Then yung 7th ground is when the voluntary dissolution of the HCP has been judicially decreed upon joint petitions of the spouses. They agree to the revival of the former property regime. No voluntary separation of property may thereafter be granted. So if na-revive yung former property regime, hindi na sila ulit pwede mag-petition for separation of property once na-granted na yung previous, yung revival. Then for the revival of property regime, it should be filed within the same court proceeding. Then the agreement under oath shall specify yung properties na to be contributed, properties na ma-maintain as separated, and names of all creditors, kasi kailangan after ma-revive yung regime, yung bibigyan kasi ng copies lahat ng creditors no agreement. Then no voluntary separation of property may thereafter be granted once na-revive na yung property regime. Then what are the effects of separation of property? So according to Article 137, the HCP or the CPG will be dissolved and yung properties will be liquidated. For Article 138, the provisions will be applied after the dissolution of the property. Article 139 naman is the petition and final judgment must be filed in appropriate registries, kasi para pag yung mga creditors, malalaman ng creditors if ano ba yung properties na conjugal or yung specific lang to dun sa isang spouse. Then rights previously acquired by the creditors are not prejudiced. Then for transfer of administration to other spouses, so kailan ba ito nangyari? It is when one spouse becomes the guardian of the other, when one becomes an absentee spouse, when one has a civil interdiction, and if one spouse becomes a fugitive from justice. So the court shall appoint a suitable person to be the administrator if hindi qualified yung isang spouse because of incapacities, yun. So that is all about chapter 5 of the CPG.
will be discussing Chapter 6, Regime of Separation of Property under Article 143 to Article 146 of the Family Code. Regime of complete separation of property. Each spouse shall own, dispose of, possess, administer, and enjoy his or her own separate property, whether acquired prior to or during the marriage without need of consent of the other spouse. So, under this regime, each spouse retains individual ownership of property that they had brought into the marriage or individually acquired thereafter. So, in this regime, each spouse may declare that a certain property be considered as their separate property. So next, Article 143, the future spouses must enter into a valid marriage settlement stipulating their property regime. In this case, the marriage settlement shall govern by their property relations. So under Article 143, it says that if the contracting parties wants that their property relationship shall be governed by this regime, they must enter first into a valid marriage settlement stipulating such regime. So, for the regime to be valid, it must be clearly and completely written in the marriage settlement, since it will become the basis of the property relationship if the marriage did not work. So, Article 144. Separation of property may refer to present or future property or both, and it may be total or partial separation. In the latter case, the property that was not agreed upon as separate shall pertain to the absolute community of the spouses. Under Article 144, it says that each spouse or parties may agree to the extent of their separation of property. It involves present or future property. It may also be total or partial. If it is impartial, the properties not agreed as separate will pertain to the absolute community because of the rule that if in absence of marriage settlement or if the agreement is void, in absolute community shall govern. So next. Article 145 is about property acquisition during marriage. So, under Article 143, it says that each spouse may enjoy possession separately without getting any consent from the other spouse. So, next please. Article 146 is about obligation in charges. Under Article 146, it says that if the party or the future spouses choose this regime, the means of supporting their family is through the means of the use of common funds. So the contribution must depend on the income capacity of the spouses. So next, please. The liabilities of the spouses to creditors for family expenses shall, however, be solidary. So it says that all liabilities and expenses for family purposes shall be shouldered by both spouses. So that's all.
Right. So I'll be discussing property regime opinions without marriage. So, in this case, there are only two articles that actually scope anything that is without marriage. So, when you take a look at it, it's either going to be 147 or 148. So, very quickly, I'm going to give you a distinction of when is it going to be 147 and when is it going to be 148. So, first of all, let's do this first. General rule, in a void marriage, regardless of the cause thereof, the property relations of the parties during the period of the cohabitation is governed by the provisions of 147 or 148. The exception is marriage declared as void ab initio under Article 40 of the Family Code. You can just quickly reference this. Alright, property regime under Article 147. The key point as to the applicability is that 147, the parties are capacitated to marry each other. It's just that they're not, and they're cohabitating. In 148, they have legal impediments, making them not capacitated. It could either be bigamous marriage, polygamous marriage, or bigamous marriage that is not scoped under Article 41 or the reappearance of the spouse. Incestuous marriage under Article 37, and then against public policy on Article 38. So when you read the case and you see that somebody has been married prior or is they have any legal impediments, it would be scoped by Article 148. Otherwise, Article 147 is going to apply. So Article 147, when does it apply? Again, they must be capacitated to marry each other. They live exclusively with each other as husband and wife, and their union is without the benefit of marriage or their marriage is void. Usually for Article 147, it's Article 36 or psychological incapacity. That's nice for it. So again, a quick refresh, what is capacitated, male or female, age 18 and above, not under 37 or 30. Next is. All right, distribution of properties. The key difference between 147 and 148 for wages and salaries, 147 is common. Okay, it's presumed that it's an equal share. And 148, kanya-kanya kayo. Alright? Property acquired by both through their work or industry shall be governed by the rules of co-ownership. In the absence of proof to the contrary, properties acquired while they live together shall be presumed to have been obtained by their joint efforts, work, or industry, and shall be owned by them in equal shares. If you would do a case digest on the cases assigned for property regimes, where it concerns 147, even though they've provided proof that no, actually I contributed this much more into the property, it's there has to be weight otherwise. Kasi nga, ang assumption is you are married talaga in the first place. There's just an absence of the marriage itself. So what governs is the equal sharing. So the weight of the proof to the otherwise is in the party alleged. So when only one of the parties to avoid marriage is in good faith, the share of the party in bad faith, and the co-ownership shall be forfeited in favor of, again, in hierarchy, the common children, in the absence thereof, the respective surviving descendants, and in the absence thereof, again, the innocent party. Next slide, please. Okay, prohibition in alienation of share, very quickly. In other words, either party may dispose his or her share in co-ownership only in the following instances. If the disposition is by the way of acts of mortis causa or gift during death in anticipation of death, even if the disposition is by the way of acts inter vivos is within the lifetime, if the same party is with the consent of the other party. Last one, please. All right, property regime under Article 148. Again, as I mentioned, applicability, bigamous marriage, adulterous marriage, anything that is not scoped within Article 147 goes into Article 148. So common law spouses suffer from legal impediments to marry or when they do not live exclusively with each other as husband and wife. By the way, this is one more crucial point for 147. They must live together. They must cohabit. Next slide, please. Okay. Distribution of properties. Again, wages and salaries earned to each belong to him or her exclusively. Only the property acquired by both of them through their actual joint contribution of money, property, or industry shall be owned in common and in proportion to their respective contribution. The share of the party validly married to another shall accrue the property regime of such existing marriage. So it shall prevail if you're under a bigamous marriage. Okay. If the party who has acted in bad faith is not validly married to another, his or her share shall be forfeited in the manner already here to express, as in the previous article. The foregoing rules on the forfeiture shall likewise apply if the both parties are in bad faith. I think we have a few more minutes to discuss this. This is case at, so very quickly, case at bar. This is case number 91 in our syllabus. Mercado Fer versus Fer. Quick facts, parties marriage was annulled. They have a condominium unit. It was declared as an exclusive property by the respondent, the husband. The petitioner filed a motion for reconsideration and alleged that the property was purchased on installment basis at the time when they were living exclusively with each other as husband and wife, again without the benefit of marriage. Now, the main issue is whether or not the condominium is Bruno Fer's exclusive property. So the court ruled in favor of the petitioner and held that Suit 204 is a common property and the proper regime of the party should be divided in accordance with the law of co-ownership in Article 47 because in this case, they lived as husbands and wife. they don't have any legal impediments. So the assumption, again, unless you were able to provide proof to the contrary, is that it's illegal. So that wraps it up for property review. Title 4. Thank you.